Yurman. I'm a partner at Debevoise in Plimpton in New York. I focus on IP litigation, so trademarks, copyrights, design patents, not really the tech patents. I have a different team I push that to. But a lot of really fun cases, and we'll talk about some of them today.
She's also ranked, I'll chime in at the end because I know you're not going to brag about yourselves. She's ranked in Chambers for intellectual property. She's included in the top 250 women in IP list and managing IP. She's a top practitioner by World Trademark Review. She's a very big deal, essentially. She is at the forefront of the fight on dupes and fakes and really takes a perspective of digging in because not everything that's a dupe is illegal, which we'll talk about. She received her JD with honors from Rutgers, where she served as the production editor of the Rutgers Law Review. She's a member of the bars of New York and New Jersey and admitted to practice before the Southern and Eastern Districts of New York and Jersey.
Hi, everyone. I'm Christina Mitropoulos. I'm IP counsel at Louis Vuitton. So I work with a team of 2 other attorneys, and we handle civil enforcement for the United States and Canada for the brand. And I've been with the company a little over 3 years now, and I had an unconventional path to in-house. So I worked for 2 trade associations prior to joining the team. So I was at the American Apparel and Footwear Association based in DC, and then the International Trademark Association.
And also at the American Apparel and Footwear Association, she led brand protection priorities, served as liaison to the Brand Protection Council, and regularly engaged with policymakers. She earned her Juris Doctor from the George Washington University of Law, and she holds a Bachelor of Arts in the Classics from Trinity.
Hi, everyone. I'm David Eshmoili. I'm the general counsel at David Yurman. Been in this role for about 8 years now, and I'm genuinely embarrassed for what Francesca is about to say about me.
This was all pre-approved, David. He leads, at David Yurman, he leads the global legal and compliance functions. In his role, he works with the C-suite, board members, and fellow David Yurman teammates. Prior to David Yurman, he was the GC and corporate secretary at Livestyle, a multinational media and entertainment conglomerate. And before that, he was at Simpson Thacher, where he focused on private equity and M&A transactions. He earned his Juris Doctor from Cornell Law School and has a Bachelor of Science in Economics from Binghamton University.
Hi, everybody. I'm Tamara Rabenold. I am a licensed private investigator and owner of Vaudra International. We're a IP investigations company. IP is our heart, our soul, our core, and we've been doing this for over 23 years. So happy to be here.
And Vaudra is a women-led and owned, a WBEN, which is women-owned and led certified company with over 20 years of experience in the IP investigations industry. She leads a dedicated team that focuses on investigative solutions. She's also super active. She's at almost every single event and really tries to pour into her community. She sits on the board of Brand Action as well. She holds a Bachelor of Science in Integrated Marketing Communications from Winthrop University, graduating magna cum laude, and is a licensed private investigator in North Carolina. And with that, obviously, we have some of the leading people in this space on how to protect brands, how we're actually going out and fighting fakes from not just an in-house perspective, but a firm perspective, and also boots on the ground from the investigations perspective. So maybe we can start first by defining a dupe. And what exactly, Megan, maybe this one we can start with you. What is the difference between a dupe and a counterfeit?
Sometimes not much. Sometimes it really depends. And basically, especially in the United States, there are legal knockoffs. And so the whole fashion industry, let's just use that as an example, like it is trend-based design protection, like strict design laws have been rejected by Congress. And the idea, and there's many reasons for it, like you're allowed to copy trends. There's no monopoly of certain designs. And so it's hard to get protection. And so what you need to look at when you're, now we have this dupe culture. So dupe culture, there's been dupes and knockoffs for as long as products have existed. But what we've been seeing over the last couple of years and really over the last decade is this dupe culture. And now suddenly you have people who are making their living, making TikTok videos, for example, saying, here's how to find dupes. Here's how to find lower priced versions of your favorite products. And that in and of itself, it's not illegal to do that. But the question is it being done in a way that infringes on intellectual property. And so because this has been happening, because it's now becoming so prevalent that there are people actually like instructing people how to dupe your brand or how to get lower priced products, what we've seen is brands getting even more creative on how do we protect our products. Because IP law is not always perfect for designs in the United States, you have standard trademark infringement. And yes, if someone's copying your name, that's an easy case. But if somebody is saying, like, we're trying to look like you, but not enough, the question becomes, is what this dupe doing causing consumer confusion? And a lot of times the answer is no. Like, if somebody's saying this is a dupe, they're saying this is not that product, it's something else. And so confusion can be a problem. And so I'm sure we'll talk about it, but that's where you have to really think about creative strategies.
Yeah, and that's like part of the problem is if you're bringing a traditional trademark infringement claim or even trade dress, if a consumer knows they're not buying the real thing, there's no confusion. So we're seeing that in some of the cases, and it's requiring lawyers to think a little bit outside of the box and leverage your IP tools, but also IP adjacent tools like false advertising and marketing. We can kind of segue into that where, because it's something that businesses have to live with, especially in the United States, where it takes a very pro-copying stance versus Europe. David, how is a brand like David Yurman really picking and choosing which targets to go after in our dupe society?
It's a great question. I mean, look, I think one of the mistakes brands make is not taking kind of like an individualized analysis to these sorts of things. I think you can get in a lot of trouble taking kind of like a one-size-fits-all sort of approach. And I also think, going to what Megan said, you kind of need to disassociate the emotions from this a little bit. Because, I mean, me personally, I'm sure all of us on this panel, we see something that we know, and it's a dupe, they're copying your brand and, what you created. Like, I get like a visceral, like, angry reaction. But
because it's stealing. It really is stealing. It's misappropriation.
Yeah. Absolutely. I mean, people who've never created something ever a day in their life and just, But at the end of the day, that's not going to get you very far in court, right? So you have to like analyze it based on what IP rights do you actually have? What claims can you actually make? How viable are they? Are you actually willing to invest in this? Who the target is? I mean, a lot of the people we come across, not a lot, but there are some targets we come across, and it's literally, a college student running a business out of their dorm room, drop shipping from like Timor or something. And I'm not necessarily going to want to sue an 18-year-old into oblivion. So, each case you have to approach it kind of differently based on the facts and circumstances and all that. And I think when you don't do that, you get yourself in a little bit of trouble.
Christina, what's Louis Vuitton's approach? I know, some companies will work primarily with outside counsel and outside firms, but Louis Vuitton is one of the most enforcement-focused companies, and they've done a great job at enforcing their rights such that they've actually helped really build the case law. So the laws that are around counterfeiting. What does Louis Vuitton think about when building their target list? And also, do you include any false advertising marketing claims? Have you taken that angle?
So similar to what David was saying, we don't take a one-size-fits-all approach. We have to look at all of these targets again based on a variety of factors. So we'll get leads from a number of different places. We have investigators throughout the country, so the investigators are working on our behalf and surveying different marketplaces. We have investigators that we send to trade shows, so if they see something, they'll inform us and ask us whether we want to move forward with a buy. So our investigative network is pretty extensive. A lot of what I do day to day is looking online and kind of seeing who's selling on what platform. And we have an interesting structure, so we're not handling online enforcement day to day. That's happening with our team members that are based in France. But if there is a target that we see that's selling online and they have a physical presence in the US or Canada, then we're able to potentially make a purchase and pursue action against that particular target. We also have a customer complaint line, which is always very interesting to see what leads we get and who is mad at their sister-in-law who's selling fake bags and then happens to turn over her contact information for us to pursue. So we do get leads from individuals who, similarly, they feel very passionate about the brand. They're investing in the brand, and they, take pride in the fact that they're buying authentic product. And then they come across someone in their town or someone online who's selling counterfeit or infringing product, and they feel very strongly about that. And again, that goes to brand loyalty. So we have individuals that will inform us about what's going on, which is always very entertaining. But again, looking at all of these targets, so developing the target and kind of identifying is the first piece, right? But then making a test buy, seeing what comes into our office, analyzing it. Do we want to take action against this particular target? And then also seeing, are they selling 5 handbags or are they selling 500 handbags, right? We're not going to pursue action against every single person that's selling a particular product that's counterfeit or infringing, right? So kind of evaluating, well, is this a target that potentially we can get monetary recovery from, right? Because to David's point, if we're going after someone who's selling out of their dorm in college, that's probably not likely for us to get, significant recovery on. But if we have a target that's selling, at a flea market every Saturday and happens to have hundreds of handbags on hand, that's a different scenario. So it's, again, case by case. And then if we do decide to pursue action against a target, more often than not, we'll send out a cease and desist letter. We follow a very cut and dry template that we send to particular targets, right? We're not trying to be cute. We're not trying to be funny in these cease and desist letters. We're laying out our rights. We have seen our cease and desist letters get posted online in a variety of Reddit forums, which is also very entertaining. But for that purpose, we keep things very straightforward, outlining our rights, how this particular target is infringing on our rights, and then laying out the demands that we're asking that particular target to follow. Sometimes we'll get a response, sometimes we will not, and we'll get ghosted. But again, it just depends on the target. So then it kind of moves into the arena, do we pursue back and forth correspondence, do we engage outside counsel to then take it a step further? And then if we put this target on notice and they continue to sell and kind of dismiss the cease and desist letter altogether, at what point then might we consider litigation? So again, there is a lot that comes into play when we're evaluating targets, but it's interesting and, constantly changing day by day depending on the leads that we're getting.
The important point there is that you have a strategy and that you're being consistent with the strategy. We're dealing with 2 of the biggest, most famous, sophisticated brands out there. Yes, it's absolutely, it's not possible to go after anyone who is doing something with respect to Louis Vuitton, but you have to go after certain people in a consistent manner and be able to justify why you're not going after someone if you're not, because then you do weaken your rights if you just let it go. The other thing that you need to do is you need to be consistent with your arguments, because if you're saying to one infringer, you're infringing and this is why, and you're saying to another one, you're infringing and it's a different reason, that is what then I'll take as a defense lawyer to say, you actually don't have rights because you're enforcing them all in a different ways. And by the way, I'm on the plaintiff and defense side, but it's something that you have to tell every client who's about to bring a claim. If you're not consistently defining what your rights are, you're going to lose them. And we can talk about some examples. It's really, really important.
So I'm not a litigator, but I have a really interesting role where I sit in the middle. So brand protection is an area that sometimes a lot of paralegals or non-lawyers handle, but I got into it from an attorney perspective. So when it comes to target lists, we'll help clients that have a mass knockoff problem. So they're dealing with thousands of infringement across different platforms. And so our method is get the tech software, which there's a bunch of tech programs here today, including Mark Vision, Copa, and I think Podkey. And what you do is you monitor, detect, but then get all the listings and you put them into buckets. Some are good targets for litigation, like what we were talking about, but then which are good targets for cease and desist letters, right? And then everything else, if it's infringing, do the takedown. And so that's a little bit about like target building and what actions to take. But Tamara, I want to turn it to you because you have a really interesting boots on the ground perspective. So we'll pull in Tamara when we need to now dig in and find out who are these people? Where is it coming from? Can we draw connections and start building out the supply chain? Because like I mentioned in the beginning speech, it may look like it's hundreds of people operating, but really it's 1 to 2 networks of illegal businesses that just are laundering their money through fakes. So when you are seeing that side of it, do you have any war stories for us on like who these people are and what kind of operations they're really running? Like what's behind the counterfeit goods that consumers don't see?
Gosh, I mean, if I knew it's been said a couple times, there's no one size fits all. And that is so true with the counterfeiter, because you do have the scenarios where you have, the mom and pop shop that kind of pops up out of a garage and now is on eBay, or, they happen to get their Gen Z daughter involved and now they're trending on TikTok. And so you have that kind of like iteration and growth. And then you have the ones that are more sophisticated that have built these networks. They're, they've figured out all of the kind of loopholes when they're on the different platforms, how to evade detection, because they're also talking amongst themselves. So, just like there are Reddit feeds for the good guys, there's Reddit feeds and various other WeChat channels for the bad guys, and saying, okay, here's who's enforcing now and how to avoid the takedowns. We see that consistently when we're doing enforcement online. So it's like every case is different, and the way the evidence ends up lining up, it's just like, okay, what are the threads we can pull for that actionable intelligence that's going to best inform the brand's next step on whether this target is worth it or not? Like, is it going to, because you're always having to find that balance to make sure you're effective, because you can't go after everybody. And of course, they're also counting on that. So it's a numbers game of like, okay, they outnumber you, but who's going to make the impact in that ripple effect of like, okay, let's shut her down.
How do you guys think, this is a loaded question, how do you think that social media has impacted the battle? Because social media has been around, over 10 years, but now these platforms have evolved into becoming e-com platforms. You can run ads to fake websites. So how has that kind of changed the way that your enforcement programs, or how you help brands enforce?
The reach is just so much broader now, where again, back in the day when social media was not a selling mechanism, you were more localized, or these counterfeiters were more localized in their endeavors. But now that you can go live, I've watched many a Facebook Live video of people selling out of their homes and their garages where they've turned them into showrooms, and they have full inventory, again, as you would in maybe a retail store. So again, now seeing the reach that social media has afforded a lot of these players, they recognize that they can sell beyond their immediate community, and they can sell across the United States and globally. So I think it's just expanded their efforts significantly. And an interesting point on like dupe influencers. So when I was at the American Apparel and Footwear Association, we published a report on dupe influencers. And granted, this was almost 6-7 years ago, but there's now also an economy for influencers, I think we mentioned this earlier, that now see that this is a growing demand from their followers. So we had seen a lot of these influencers that, again, I'll find you this dupe of X product, or, again, at the time we were seeing a lot of counterfeit products being advertised by these sellers, but they were becoming so sophisticated that counterfeiters on various platforms like DHgate were actually sending product to these influencers to review, and then they would do their whole, reel or their post about how great this counterfeit product was. Here's 10% off, use my promo code to buy this, particular product on DHgate. And there was a whole network that came out of that. There were giveaways that were being advertised. And so it was just interesting to see kind of how the influencer economy is also growing. And now a newer trend that we're seeing is Canal Street personal shoppers. So now on TikTok, there is a growing demand for people to send these personal shoppers to Canal Street. So they will go throughout the week and say, yeah, this particular person has these new Chanel bags in stock, who's interested? And then they will actually get commentary from their followers, buy that bag for me, buy this Louis Vuitton wallet from me. And then they've set up this whole economy now where, again, they see that this is in demand, and there is a whole network now of Canal Street influencers. So it's fascinating to see how social media is also evolving with a lot of these trends too. But I think people are seeing that the reach is there and they can capitalize on it.
One of the things we've been seeing is there are influencers who are showing how to dupe a dupe. Like, it's like, here are elf dupes or here, and I'm like, it has really gotten out of control. Like, it's working, and people are making money, and brands are losing money because of it.
The other thing I would add to that, though, it's obviously the reach that you get and all of that. But the same way that we brands will use social media as a customer acquisition vehicle, so are these people. Right. Like, they're, I sometimes get emails from folks, executives or other employees at David Yurman, because they're on Instagram or Facebook or whatever. They follow jewelry accounts. They're like, looking at these sorts of things. So the algorithm targets them with advertisements for dupes. And they probably get targeted for that disproportionately based on where they live and where they work and what they look at and all this other stuff. But they're very good at finding target audiences and using social media in the same way that we brands would, but for nefarious purposes.
Yeah.
The social media game is wild. And when it comes to social media, Tamara, how are you helping to capture that evidence? Because I know, like, 10 years ago when I started this, I was at a big Italian fashion company, and we would get our outside counsel reports, and it was mostly focused on physical marketplaces. Because even 10, 15 years ago, luxury brands weren't really doing e-com. It was seen as, if there's stuff sold online, it's clearly a fake, and our customer knows and doesn't want to buy the fake. So we're not so worried. But now, with helping brands and supporting them, has it like overwhelmed you with the places and the evidence gathering? Like, how do you guys zone in on which social media evidence to gather?
Well, it certainly kind of depends on the application and what the end objective is, because you don't want to capture the entire internet, because then it's pretty much all worthless. So it's really making sure that you know what the brand is focused on. And then if it's a particular seller or if it's a particular style, like depending on what's the legal strategy and the story that you're building, and then making sure you kind of go deep in that evidence on that topic, so that if it's talking about a shifting trend and now there's all of these sellers, well, you want to identify all those sellers and then make sure you're capturing what they're doing, what they're talking about, what they're posting, and then what about the other platforms where they may also exist, and make sure you capture it there. So we're capturing the digital evidence using a number of tools, making sure we have the metadata, making sure that we also capture, the chats, the comments, and there's a lot of different ways to do that, some of them more effective than others. And sometimes you kind of have to double up because social media doesn't like you capturing things. So like the scrolling can get really jammed up. So then you're also doing a combination of still shots. And of course, then we also will have undercover dialogue, which is key evidence if you have that capability and that's, an acceptable opportunity with that particular target.
Yeah.
That they're not already represented by counsel as it relates to the situation, but having that kind of dialogue so you can be more of that, hey, posing as that interested consumer and learn more about the different channels where they're offering, the pricing, the availability, the volume, the speed at which they can ship their supplier, and working into that kind of broader distribution conversation.
And when it comes to some of the things that I've seen on social media, with influencers, for example, because a lot of this is like, it's more of an art form than a science, right? You could send off a fire and brimstone C&D, but that may not always be appropriate especially because it can get posted online. So it really depends on the business. So we had a celebrity influencer who started a consumer product company and went viral. Her name, her image, it's overnight that she got completely knocked off to the point where there was thousands and tens of thousands of infringing listings. So part of the cleanup for us wasn't just, hey, let's get these sellers down. There was a whole economy of the influencers. And she was really popular on TikTok and Instagram. So we did a whole separate C&D program where we would send softer letters to the influencers basically saying, hi, I'm so-and-so. I'm the creator of this brand. It looks like you're selling a counterfeit product. This is illegal. I put my blood, sweat, and tears into this. However, we would love to send you the real product, and we'd like to plug you into our own affiliate program. So rather than just like fire off a whole bunch of cease and desist telling them to stop, they took a more collaborative approach and were able to pull some of those influencers away. So that's one thing. And then the other thing that we're seeing is people will remove the listings and then they sell in the middle of the night when they think like we're all sleeping. But the great thing about having tech tools and like all the platforms that are here today, the good thing about that is you can actually be monitoring and scraping at those weird times. So we were able to catch somebody who we had a settlement agreement with that swore they stopped selling, and we caught them, and we actually were able to do a buy quickly as well, and we're reopening up that. It's the wild, wild west. But we could stay on the social media thread. I think this is an interesting one. How can brands in a proactive way use social media to educate their consumers on, let's take this really narrow, on how to, for trade dress? So like how can they use social media to tell customers, even if they're not using the name on the product, here's what you look for to buy a real product? Megan, do you want to maybe start this and we could talk about MZ Wallace?
Oh, sure. Okay, so look for advertising is one way to help establish secondary meaning. Secondary, if you have a trade dress. Trade dress it's a trademark, but it's a trademark in the design of a product. It's notoriously hard to achieve because if you're trying to achieve protection over a design, you have to show secondary meaning. What does that mean? You have to show that a large portion of consumers see it and immediately know that it's your brand. And so there's different factors that the courts look at. One of those factors is what we call look for advertising. Are you specifically advertising to your consumers these design features? And, then a court is able to infer consumers would know what those design features are because you're specifically advertising. Now, one of the things that we talk to our clients about is, you have to get in line with your marketing team early on. And you have to first of all figure out what about this product, what are the elements that we're trying to protect. And a lot of times brands don't think about this until there's a dupe. And then what you find is your marketing team's been advertising all the wrong things. They've been inconsistent, like we've been saying different things. And so it's really hard to do, like to all get on the same page before there's a threat. But to the extent you can do that, it's really going to be helpful. And we'll talk, Francesca asked me to mention this MZ Wallace case. So
you don't want Megan on the other side of you. I mean, actually, we have been on the other side, and it was great. But
how did that go? I'm here. It must have gone okay.
But she will pick it apart.
I like to be on the brand side. I think it's really important. But if I have to be on the other side, this is why I'm going to tell brands what they should do to not run into these problems. So who is familiar with MZ Wallace handbags? All right, they're quilted handbags. MZ Wallace took a bunch of actions and wrote a bunch of cease and desist letters to various companies making quilted handbags, one of which was my client, Oliver Thomas, who also makes a quilted handbag. And so they ended up, MZ Wallace sued Oliver Thomas for infringement, and essentially were like, we own the quilted handbag design. There's a lot of things wrong with that argument, considering how many other brands, very high-end luxury brands, make quilted bags. They weren't picking on the luxury brands for obvious reasons, but they were picking on some of the, what they saw as easier targets. And so one of the arguments we made was you actually have no valid trade dress. And if you move forward with this, we're going to invalidate your trade dress. But they sued anyway. And we ended up invalidating their trade dress. We had a court say you have no valid trade dress. And there were a few key elements there to get that ruling. One was the point I made before, which was the consistency of articulation of your trade dress. What we found was that every time they sent a cease and desist letter, they defined their trade dress based on the infringing product. So they would take whatever the infringing product was and say, all of these features, those are our trade dress. And what we did at trial is we made this huge chart, this big demonstrative, and we put like all of the 30 elements that they had claimed as part of their trade dress, and we color-coded what was actually being claimed here. And the judge is like, if you don't even know what your trade dress is, how are consumers supposed to know what your trade dress is? No trade dress rights. The second thing was their marketing team was doing look for advertising on like totally functional elements. Like they were saying, you carry an MZ Wallace bag because it's so comfortable. It can carry so much stuff. It like is great on your shoulder. And the way you identify it is this brown logo that says MZ Wallace. And we're like, exactly, that's how you identify it. It has nothing to do with the design. And so the judge got really mad at them, and it just completely obliterated.
And that was a social media post, right?
It was social media.
So it could have been like a college intern that did that. But if you have good lawyers, they're looking for these things.
So it's consistency with the articulation. And it was the first time we saw a court really say, like, whoa, you sent all these different cease and desist letters. Like, that completely cuts against you. And so really, really important. I've clients on the brand side I'm working with now, and we've filed some litigation recently, and now there's other infringers out there, and I'm like, no, we have to keep that trade dress definition the same. It is really important to keep your rights the same, and so we have to think about it.
So we have two of the most iconic brands here that also have trade dress and registrations. I know that there's trade dress registration on the cable bracelet and copyrights, which is great. So David, what kind of strategies do you have when kind of leading and your marketing teams and the business teams on being really clear?
Look, I think it goes back, like we're all kind of saying the same thing. I think at the end of the day, you really need to have worked out a strategy ahead of time on how you're going to approach brand enforcement in general. At the end of the day, the value of any piece of intellectual property, you're trying to protect something of value to the business, whether it's a name, whether it's a design, whatever it might be. You need to figure out like what are the key elements that drive the value of the business? How can we protect those? So that's like one kind of strategic decision. And then if we're finding infringers, because there are a lot of them, what are we going to focus our efforts on? Are we going to try to clean up eBay and Poshmark? Are we going to try to go up the value chain and try to go after distributors, manufacturers, like overseas? Like all of these things need to be kind of worked out ahead of time. So you have a clear strategy, and that gets you out of the whole sort of whack-a-mole thing, which is just inefficient and probably not going to drive, like, on the surface level, it'll look like you're accomplishing things, but you're really not. So like being able to have that strategy worked out ahead of time, and then socializing it internally with your marketing team, with your design team, product development team. I mean, I think one of the things you can do as a lawyer is actually try to be in the design room in the earlier stages. If there are tweaks or things, I mean, obviously you need to know your boundaries, but if there are tweaks and things you can make, that's like, oh, I'm going to put something, how about we do this instead of, X instead of Y, because that'll add a level of distinctiveness. It won't be so generic. It won't be the same thing these 30 other brands are doing. And if it still works for you, design team, like, how about you consider my little idea? But, things like that. But it all ties back to you need to have the strategy worked out ahead of time of, like, what do you want to protect? How do you want to protect it? What's the story you're going to tell? Right? Being consistent with that story through your marketing and advertising teams. And ultimately, as Megan has been saying, in your cease and desist letters, in your complaints, all of that.
I mean, David raises a great point. Like, if you're able to just ask your designer right at the forefront, like, what is original about this? What is, like, protectable? What is different about this? And get them on board right from the beginning, too. Because sometimes what I find is we're, like, very later trying to protect these things, and you meet with the designer, and they're like, nah, no, I don't know. And you're like, no, wrong answer. Like, let's rewind. And so you're just kind of, like, setting the right mindset from the beginning. And look, I can't pretend, like, obviously, like, I mean, how many different things do you guys have to do every day that it's not like you have tons of time to be like, let's go meet with the design team on every piece of jewelry. But like coming up with a way to do it, at least on the very important pieces or elements of your brand, is like pays you dividends down the road.
Yeah.
And I'll add, our portfolio team that's based in Paris will meet with the design team on occasion, and they have a form that they will send, depending on the collection, if we want things to be cleared. Where did the inspiration come from? What were the sources of, inspiration for this particular product? So that way we also have a paper trail, should we ever get to the point of litigation where either we're suing someone or someone is suing us over a particular design, to have that comprehensive overview, or to the extent that it is comprehensive, all of that information is at our disposal.
Yeah. And building trust with the teams, right? I know a lot of people say, legal's where things go to die. But if you can, if you can build a relationship where the business unit is actually, proactively working with you. I was seconded in-house at a global fashion company, and I would actually I had a weekly meeting with the design team, and not just, from a trade dress perspective, but they would use things like the Empire State Building on bags. They did this New York collection, and immediately I was like, that's a registered trademark. They're like, what? The Empire State Building? Yes, like the actual Empire State Building design is a trademark. So, you can catch things like that, not just from a trade dress perspective, but if you build up that, trust in the teams, then you could actually save them a lot of time and heartache.
I mean, right now with the dupe culture, it's like you're now brands are taking it to the next level. Like, what can we do to make sure we get more protection because of the craziness of what social media has done to dupes and made it a concept that's always been around skyrocket. And that's why it's even more important to be thinking from the outset, like, what element might we be able to get trademark protection on? Where might we be able to get copyright protection? Like design patents, the USPTO continues to hand them out like candy. Like, what is important enough to get a design patent on? Because those are potent tools right now.
Yeah.
And like looking at the advertising claims, like some of the biggest dupe cases we have right now, it's like, we're going to bring an infringement claim or dilution, I think. Nobody ever thinks about trademark dilution. But there are state statutes that do not require fame, like the New York state dilution statute does not require fame. And like dupes are diluting your brand value. Like, how can you say that if there's something out there that looks the same, and you don't need confusion for dilution, but there is dilution. And so like dilution claims, false advertising claims, when somebody's saying this is exactly like the product, you just have to be really creative. And that's the type of thing that we're thinking about now in order to beat back some of these claims.
Yeah, let's shift into that. I know we have 10 minutes left, but I think this is the most critical part is thinking outside of the box. So when it comes to false advertising claims or dilution claims, what strategies have you guys integrated? And I'll just say one quickly on our end with counterfeiting cases. If they're copying the label, we've seen it where if it says made in the US and it's not, then
false
advertising. There's definitely claims. So I think it's good, even if you're just an IP lawyer, to really bring in other types of lawyers or other claims to have that suite of tools. So maybe David, do you want to talk about this at all? Or have you included that? I know you're doing a million things, but is it something that you guys kind of think about versus just the traditional copyright infringement?
Yeah, yes. I mean, you have to in today's environment. I mean, we look at whatever tools are any point of leverage that we can possibly find. We will do that once it gets to that stage.
Yeah. And you guys too, Christina. I've seen some of the cases.
Yes, we have. And similarly, we also have been investigating a target that is upcycling certain products, but then also reselling what is purportedly vintage Louis Vuitton products. But then part of their disclosure is handcrafted in the USA, which, as we know, is not correct. So we have also looked into some of those claims as well.
I think in both, what people know about both of your brands is that you will take action. You have both filed aggressive cases. And I think that's important to send the message to infringers or to dupes. If you cross the line, you will get sued. And then for the brands, just be strategic and pick and choose what cases you're actually filing. Because the MZ Wallace example, it can go all wrong.
Yeah, yeah. And Tamara, from your investigative perspective, how have you started thinking? Because it's not just okay, take a screenshot of the product infringing. Like, how has that kind of changed your strategy to think of more of IP adjacent tools and claims?
Well, something that I think we've all kind of touched on, but it hasn't been said specifically. It's like you also need to make sure you have an evidentiary sample, because what they're doing online can be totally different than what you actually get. And so determining that, like taking care of that piece of it.
What does that mean for people who don't know?
For making an online buy and making sure everything is documented from your first visit of that website or step in that store all the way through the evidentiary chain with the proof of purchase, the proof of shipping, the tracking, proof of receipt, and making sure that all of that is documented, because you may also find things along the way. Maybe there's mail fraud. Maybe there are other things involved in that, if there's, depending on that, follow the money. Sending the money is the way to follow the money. So making sure that you also kind of have those opportunities at your disposal, because you also could find other viable threads to further identify that party, further identify other assets. There's a lot of different ways to go about it.
Yeah, yeah.
Oh, I'll add, having that evidentiary trail is huge, because we've written to targets and, shortly after they receive the cease and desist letter, everything vanishes from their social media account or their website, and they deny that they ever sold anything. But then, we politely respond and say, well, this is a picture of you holding up this bag. Can you confirm or deny that? But having that trail is really, we try to be very forward thinking. If this person completely shuts their social media account down tomorrow, if the website goes down, do we have as many screenshots or, as many lives or recordings that we can then establish a potential case in the future should we decide to pursue litigation? So I think having that forward thinking element is huge.
And then I would just end with, and we could take one or two questions. That is such an important piece, right? It's talking about a program. We're talking about brand protection programs that include litigation and include cease and desist and takedowns. But such an important piece, and which is why I'm glad Tamara's here, is the actual investigative area where you, like David said, you could play whack-a-mole all the time. If your executives are saying, well, there's this site and we need this down yesterday, then you're stuck in reactive mode. But really figuring out who are these people? What is the supply chain? Doing test buys. And sometimes that's really difficult to get a brand to invest in. It's like you're spending money on an invisible problem that it's like, why am I going to spend more money on something that's costing me money? And it's because as long as you're popular, you're always going to have these problems. I think clients would have bigger problems if you're not having these problems. So it is an important piece. And I just want to say that I know a lot of the vendors that are here, like Copa, Mark Vision, and Tracer too, and probably Podkey, that having that investigative angle and working with investigators is also something that they include. So, okay. Thank you. Thanks, everyone. Great job. So we have 5 minutes. We can take, I guess, 1 to 2 questions.
So from a litigation perspective, if, say, it's, trademarks you're dealing with, there's elements of strength of the mark that you're looking at, and there'll be an argument that, well, if you let other infringers stay on the marketplace, consumers know how to differentiate it, so it's a weaker mark. But look, there's a common sense element to it too, and if it's a mom and pop shop selling one shirt or two, it's not going to weaken a strong mark. If you're not stopping an infringer that's selling 1,000 products a month or something like that, that's a much higher element. And so the law is pretty clear that brand owners or trademark owners or copyright owners, they have the ability to pick and choose who they enforce, but they just have to do it in a way, a common sense way, what's happening to our mark? And, are we letting a proliferation of products go out? So I can definitely see a situation where it's someone selling from their dorm room, so what? But now they've become a commercial enterprise, that's when you have to go after them.
But there's also the difference between a litigation target and a takedown target. So that may be something that you just do takedowns on with your vendor. And if then they come back and they write to you or they post something nasty, well, it's you're selling illegal goods. What are we doing?
So the first sale doctrine exists, right? That you're able to do whatever you want with the product. But in our view, something like an upcycled product is a material alteration of the original product. And so therefore, like taking a bag and then deconstructing it. And then we've seen, a variety of things, pieces of canvas on cow tags, on beer koozies, on hats and things, again, that they were not intended to be put on. We consider that a material alteration, so that's infringement from our perspective. But, the counterclaim that we get a lot of times as well, this is sustainable, we're taking, authentic pieces, but then we've also seen...
That's not a legal claim.
Not a legal claim, to be clear. But what we have seen is people saying that they're using authentic material and then, discussing with our teams and having a variety of ways that we authenticate products. They're not actually using authentic canvas. So then that's, again, that we would consider as we do counterfeit.
I got that claim. I sued a very, very famous influencer who everybody knows. And she admitted that what she had was fake and a counterfeit. And she was like, but it's just not environmentally friendly for me to destroy this. And you're like, okay, we're going to sue you. That was the response.
Yeah. Oh. Well, we're out of time. That was phenomenal. So another round of applause. Why not?